Justice Jackson?
So I'm still a little stuck on your initial argument, which seems to be that the subsequent intervention does not permit the government to interfere with the relator's status and rights. So the government, per the plain text of the statute, can come in, but you say at that point the relator is still controlling the action, and therefore the government can't move to dismiss or do anything other that's sort of inconsistent with the relator's control of the action. Is that, do I have right your argument?
Yes,
basically.
but it is, just to be very clear,
yes.
I'm not just making this up. In
right.
C3 it says without limiting the relator's status and
yes,
rights.
no, I understand the textual basis. What I'm concerned about is that the most definitive statement that we have related to Congress's actual intent, which I know that we sometimes don't look at or don't care about, but in this case, the legislative history, the Senate report on pages 26 and 27 say exactly something that is totally inconsistent with what you've just said. It talks about, as Justice Kavanaugh brought up, a situation in which the government has failed to intervene at the beginning, and they were concerned, they say, because the government would be barred from re-entering the litigation under a circumstance in which, quote, new evidence discovered after the first 60 days of the litigation could escalate the magnitude or complexity of the fraud, causing the government to reevaluate its initial assessment or making it difficult for the key TAM relator to litigate alone. And this is the key part. It says, in those situations where new and significant evidence is found and the government can show good cause for intervening, paragraph 2 provides that the court may allow the government to take over the suit. So it doesn't say that the government can just intervene and act as another party. It is contemplating clearly in the legislative history of the Senate that the idea is that the intervention is to allow the government to take over the suit because we have good cause. There are reasons why the relator exercising its rights can't really do it. And so I don't understand why under those circumstances you would say the government can't act as the quote unquote owner of the suit once it re-intervenes.
Your Honor, and the sentence that you read, I'm glad you brought it up. We didn't stress it precisely because the court typically doesn't look to legislative history, but it's actually a powerful point in our favor. Look at the Senate version of the act. The Senate version of the act is not the enacted version, and it was changed in 2 very critical ways.
Okay.
The proposed language in the Senate said intervene and proceed with the action.
Yes.
The final version struck and proceed with the action, just intervene. The second change, which is also critical, is the Senate version did not have the qualifier without limiting the status and rights of the relator. That was inserted in the official version.
So do we have legislative history that just explains the changes that you're talking about? Do we know why they struck those things?
Unfortunately, we do not know why, but what I do know is that when the Senate is saying, we think the government should be able to intervene and take over the case, and they have very distinct language, and the enacted version says, I don't think so. You can't intervene and proceed with the action.
So what do we do about Section 5 that says the government may, I'm talking about the statute, may elect to pursue its claim through any alternate remedy available, including the administrative? In the legislative history that I'm reading, it goes on to talk about how when the government takes over the suit, it can also decide to not continue to pursue it as a litigated matter, but can take it and put it into the administrative course. Is it your point that the government can only do that in the beginning now, based on the way you read the statute?
Oh, no, not at all, because again, look at the introductory language to C5. It says notwithstanding the action under subsection B. So basically notwithstanding the False Claims Act case, and this is a good reason that also this doesn't present any real Article 2 concern. It's telling the executive, if you would rather pursue this False Claims Act case at the start, later in the case, it doesn't matter, through another proceeding, through an administrative proceeding, through a different judicial proceeding, you can do that. And nothing about the filing of the action under subsection B, which is the private action by the relator, can interfere with the government's ability to pursue other forms of relief.
One last question. Why does the government have a right to continue to get information in the case if the property right shifts completely to the relator once the government declines to intervene initially? Is it just so that they could possibly intervene and come back and do something that is not controlling the case?
Well, I think it is, Your Honor. First of all, the property isn't assigned entirely to the relator. The government obviously gets the bulk of any recovery. But it is to give the government the opportunity to say, you know what, we think the relator needs help. Or we think that this proceeding actually would benefit from our stepping in and supporting the defendant.
What's the point of good cause? Why does the government have to show good cause to intervene unless there's some implication that the government might be able to do something that the relator doesn't want him to do?
Well, I think that there's good cause. It shows the respect for the relator and the relator's right to conduct the action. It shows that Congress really did expect the government to make that initial upfront choice, or would just say, just come in at will. Whenever you feel like it, you can come back in. But again, when they can come back in, they have to respect the relator's status and rights. And you can't limit those rights. And paragraph 2 is framed in the statute as limitations on the relator's rights. So it really is.
Thank you, counsel.